The NDAA is the National Defense Authorization Act, and it's really a lot of the funding that comes, it's really a lot of the funding. And what's this big sweeping changes that's going to happen in the NDAA in 2022 is what the Army calls SHARP, the Sexual Harassment and Assault Prevention. Those are your typical Article 120 offenses. Well, in what's going to happen in 2022, and we'll see how this is going to be implemented, but the command is going to be taken out of the decision-making process, which is the first time in the history of the UCMJ where that's ever occurred. Under the UCMJ, the command really is the decision maker, the command that could be the 05 level, the 06 level, and is typically the general court-martial convening authority, so we have a general officer level that really makes the decision of whether to send a case to trial or not. Well, in these type of SHARP-related cases, they're going to not have any discretion. They're going to be completely taken out of the picture, and it's going to be the prosecution team that's going to be making these calls. And we'll see how that plays out. I think there's some pros and cons to it, but the underlying reason it was done was supposed to be to promote more prosecutions of sexual assault and to promote, I guess, even a greater level of oversight. And I think what the folks up in Washington don't understand is there is a tremendous amount of prosecution of sexual assault now, and there has been even over the last 5 or 10 years. Really what we're seeing on the ground is that any accusation, just about any accusation of sexual assault, it gets treated as guilty till proven innocent if you're the accused, and the vast majority of those cases go to trial anyways. And so maybe it'll have the opposite effect, and where we'll have more discretion by the JAG officers or by attorneys to not take garbage cases to trial. I mean, that's the hope I have, that we're going to see more prosecutorial discretion. But I think the reality is, I don't think we're going to see that, because as a military prosecutor and as a staff judge advocate, you don't want your OER or your fit rep to, you don't want to be evaluated on your OER or your fit rep for not being hard on crime or not prosecuting cases. So I think there's going to be a lot more pressure on these judge advocates, and that can be all the way from the 03 level on up, to prosecute cases. So I think instead of seeing, more discretion, I think what we're going to see is almost every one of these cases going forward, because if a CG or a general officer is, he may, because he's already made general officer, he may be willing to not send a case to trial because he sees it for what it is. I think we're going to see a lot less of that with a prosecution team who has that discretion. So I think the bottom line is that in these SHARP or these sexual assault and sexual harassment cases, while prosecutors are going to have a lot more discretion, I don't think it's going to be utilized. And I think we're going to see just as many cases go to trial. In fact, we probably will see more.